The NCAA lost control of NIL rights, and it might be dead in the water because of it. As of this recording, a federal judge just granted a temporary restraining order prohibiting the NCAA from enforcing any of its NIL policies. In other words, the NCAA can't punish schools for going out and recruiting players with NIL dollars. This is just the latest nail in the NCAA's coffin, and most of them relate back to one thing: antitrust law. In most antitrust cases, there are 3 steps to the analysis. First, courts are going to look at whether or not there's an unreasonable restriction on free trade in a relevant market. Next, they're going to look at whether or not there are any pro-competitive effects that rationalize having that restriction in place. And third, they're going to look at whether or not those pro-competitive effects can be achieved with a substantially less restrictive alternative. This is known as the rule of reason analysis, and it's very legally intensive, so let's break it down. First, the burden falls on the plaintiffs. In this case, that's Tennessee. They need to show that there's an unreasonable restriction on free trade in a relevant market. The restriction needs to be unreasonable because technically any contract is a restriction on free trade, but that's not what the Sherman antitrust laws are concerned about. They're concerned about unreasonable restrictions that severely impair the market. And contracts between normal business people, that's not it. When you're talking about relevant market, though, that can be any market. It doesn't need to be for the sale of goods. It can be the labor market. Or in this case, it's the market for student-athlete NIL rights. Tennessee is alleging that the NCAA is artificially restricting the value of student-athlete NIL by prohibiting them from negotiating with colleges before they enter school or from negotiating with other schools while they're in school. They say that this is an unreasonable restriction on free trade in the relevant market of student-athlete NIL rights. Next, the burden shifts to the defendants. In this case, that's the NCAA. They're allowed to come up with affirmative defenses, and in antitrust lawsuit, those are the pro-competitive reasons why that restriction needs to be in place. Basically, reasons why that rule is needed. The NCAA has a laundry list of reasons why it has restrictions like this in place that they always try and pull out whenever they get dragged into antitrust lawsuits. And the main one that they tend to rely upon is amateurism. They claim that without rules limiting how much student athletes can earn and how much they're allowed to negotiate with other schools, consumers like you and I won't watch the sport because it will be indistinguishable from pro sports and amateur sports will no longer exist. And we've kind of seen that is not true. Viewership keeps going up and up as amateur sports become more and more like professional sports. They rely on a couple of other pro-competitive rationale, which I personally think are a lot more compelling, such as parity. They don't want a ton of high-profile student athletes going and competing at the same school and forming mega teams. And that is a very real and reasonable pro-competitive reason why you don't want student athletes negotiating with schools while they're at a different school. But it may not be enough. And that's because even if the NCAA goes out there and shows that there's a good pro-competitive reason for having these rules in place, the plaintiffs are allowed to come back and say that there's a substantially less restrictive alternative that would accomplish the same goals. And that's the third step of the rule of reason analysis. The plaintiffs, again, Tennessee in this case, can come back and say there's this laundry list of other ways that you can promote parity. Or they can say that parity is not as important as the freedom of the market. Either way, they're able to come back and counteract the NCAA's affirmative defense. But that's only if this is looked at under the rule of reason analysis. Typically, antitrust lawsuits are looked at under the rule of reason analysis or the per se analysis. The per se analysis is basically you look at something, if it looks like it's an antitrust violation, it's an antitrust violation. Rule of reason is what I just explained. But there's something in the middle called a quick look analysis, and it only goes through the first 2 steps of the rule of reason analysis. And this is what the NCAA really wants the courts to do when they look at this case. That's because if the NCAA can convince the court to view this through a quick look analysis, it doesn't matter whether or not there's that substantially less restrictive alternative. The analysis gets stopped short. The court will look and see whether or not there's an unreasonable restraint on the market, which it appears there is. But then they're going to look to the NCAA and ask them for their pro-competitive reasons. And if they give any valid reasons, which they will, then the analysis stops and the NCAA wins. They go back to enforcing their NIL policies and things go back to the way that they were. But that's not the way that this is probably going to work out. The court has almost always insisted on viewing NCAA policies through the full rule of reason analysis. We saw this recently in the Alston case and all the way back in the Board of Regents case. So the NCAA is probably going to have to fight through all three steps of that rule of reason analysis while having this TRO in place. Now, the granting of the TRO itself isn't evidence that the NCAA is going to lose the case. But the fact that one was granted and the opinion of the judge who granted it show that the NCAA has an uphill battle ahead of it, while dealing with an entire laundry list of new issues stemming from that TRO. Now that the NCAA can't enforce its NIL policies, it can't punish schools for violating those policies. So schools can go out there and they can recruit high school athletes or even transfer students by offering them NIL money. Like, they're allowed to sit down and have a conversation with student athletes and tell them how much NIL money they're going to get for coming to the school. This is basically pay for play, which is still prohibited by the NCAA's rules. But with the TRO, it would be almost impossible for them to enforce that rule. Schools are allowed to facilitate meetings between boosters and NIL collectives and student athletes. Like, this is something that Miami's women's basketball head coach got in massive trouble for just a few years ago. And now it's okay. And it's going to be very common practice unless something changes. Like, schools can even bring NIL collectives in-house if they want to and basically have them be under the control of the school to do the recruiting. This is wild. At this point, the options for the NCAA are pretty limited. They can try and settle this case and change their NIL policies again to be even less restrictive than the already very hands-off policy that they had, but that may be too late. They had an opportunity to do that after O'Bannon, and they had a second chance to do it after Alston, but they kept dragging their feet, and now that opportunity is likely out the window. So they're probably banking on some sort of federal legislation that would give them some sort of partial antitrust exemption. But that's likely not going to come, at least not in a reasonable amount of time. Federal laws don't get passed very quickly, and laws regarding college sports aren't going to be very high up when politicians are focused on the war in Ukraine and everything going on with Israel and Palestine. So the NCAA is likely on their own, and there's going to be some massive fallout from this. I was at an event with some of the leading sports executives and sports lawyers in the country when the news of this broke, and the sentiment was that the NCAA is too late. They may already just be dead in the water. They had their opportunities to go and make policy changes, but they dragged their feet, and now they can't do anything about NIL, and it's iffy whether or not they can do anything related to monetary gain. Basically, the only rules that they can clearly still enforce are related to academic eligibility, and that's likely not a good enough reason to still keep the NCAA around. So they may just disappear. We've already seen the Big Ten and the SEC talk about splitting off, and as more and more of these cases progress, that's seeming more and more likely. And when that happens, when, not if, is the sentiment, the NCAA is just going to disappear, because what reason do they have to exist at that point? In terms of how the TRO is going to impact schools themselves, there's going to be a race for the top. Schools that have money and want to compete for championships are going to start pumping funds into bringing in top-tier talent, whether that be from high school or from other schools. And schools that don't have big money boosters aren't going to be able to keep up. this is going to be a huge problem because schools are going to be pumping money into revenue generating sports. And since the schools are going to be involved in the recruiting process, this may implicate Title IX, and there may be issues with how much NIL money is being offered to male student athletes versus female student athletes. So that'll be a very interesting issue to watch as it progresses. Again, at that event, the sentiment was that non-revenue generating sports, such as our Olympic sports, are probably going to go by the wayside. And we're going to have men's basketball, men's football, women's basketball, and that's about it in just a couple of years, if we follow this line. And another consequence that isn't getting talked about that much, but really should be, is that some sports programs and some schools in general are going to go bankrupt. There's this other court case out there, House versus NCAA, where former student athletes are seeking damages from the NCAA and the institutions where they played because they weren't allowed to profit from their NIL. And if cases like the one we're in right now with this TRO and go on and say that the NCAA's restrictions violated antitrust law, that's more support for the House case. And if they win, they're going to have billions in dollars worth of damages to be paid out by the NCAA and by individual schools. And if the schools are set up with the athletics program as an arm of the school itself and the states are going to be on the hook for all of that money. And it may cause a lot of them to go bankrupt. The NCAA has always struggled with antitrust lawsuits, and antitrust may be the end of the association. If you want a background on the cases that led us up to this point or more info on antitrust law in general, let me know down in the comments. This is honestly my favorite topic in law, and I love talking about it. So let me know if you want to hear more and if you enjoy this type of video in general. Thanks again for watching. I'll see you next time.